All right, appearances counsel, starting with the prosecutor.
On behalf of the people. Your Honor, Harry Mihas on behalf of Mr. Bartholomew.
Morning, Your Honor. Nicole Smith on behalf of Mr. Bartholomew.
Good morning, Your Honor. Tracy Deinhardt on behalf of Ms. Bartholomew, who is present and seated to my right.
Good afternoon, Your Honor. Sarah Valenti on behalf of Ms. Bartholomew.
All right, thank you. You all may be seated. So we are here for a probable cause conference. It's my understanding there is not a resolution in this matter. Is that correct, counsel? In these matters, I should say. All right, then I'll turn to the defense. Anything for the record?
Your Honor, we need to address discovery. At this point, discovery is being held hostage. We have not received one piece of paper, not one. The only thing that's been revealed to us was the probable cause affidavit, which was released previously to social media before it was released to us. We have attempted to negotiate with the Attorney General. It's our information and belief that the Attorney General's office is in charge of disseminating discovery. They are insisting on an unacceptable discovery protective order that does not fit what we're doing here and interferes with our ability to conduct a defense and ensure client's rights. At this point, Your Honor, we're dumbfounded what to do when the whole point of this conference was to have everything and to just blow off the court's authority to not give one piece of paper, knowing that, understanding that while our clients are confined without a bond, it's unacceptable, it's unethical, and it should be sanctioned.
Your Honor, I share in the comments of Ms. Mihas or Mr. Mihas in this case. I have also not received a single document, whether it be a autopsy report, a police report. I've received absolutely nothing beyond the probable cause affidavit that was released. My understanding is to the media prior to the first probable cause hearing in this case. In fact, I received that affidavit when I opened up my own Facebook page and read it on Facebook, which quite frankly is unacceptable. At this point in time, my client continues to sit incarcerated, held without bond. If the government is not prepared to move forward with this case never should have been charged back in December when it was charged. At this point, I share the comments of Mr. Mihas. I'm asking for either this case to be dismissed if the state is not prepared to move forward with this prosecution, which at this point in time, without a single piece of discovery, and the probable cause affidavit is not discovery. Without a single piece of discovery, the state is not prepared to move forward. So yes, I am asking for this case to either be dismissed, or I'm asking for my client to receive a bond in this case pursuant to the court rules. She's been incarcerated long past the 30 days that this hearing was adjourned to allow for the discovery to be turned over. Your Honor, it's my understanding that the Attorney General's office is the one handling the discovery. And I will note for the record, the Attorney General's office or a representative is not in this courtroom today. Quite frankly, if the court is not inclined to dismiss or grant a bond in this case, I would ask for the Attorney General's office to be show cause to explain why discovery has not been turned over to the defense at this time, to explain the violation of due process in this case.
Your Honor, given statements, I want to quote from an email sent January 9th, 2026. We don't have full discovery as it's still ongoing in the investigation stage, but I do believe we will have some documents.
And that's from
Melissa Palka from the
the
AG's
AG's
office.
office.
If it's still being investigated, why was my client charged? Why was Ms. Bartholomew charged? If we're still investigating, which again, Mr. Bartholomew needs a bond at that. We've passed the 21 days. We were told, be ready, have everything out. or let's dismiss, because if you're investigating, investigate all you want, but my client should not be held in that.
And when did you each follow your demands for discovery?
I filed my appearance and demands immediately. I believe it was December 2nd or 3rd. So the 21 days to follow through with the discovery request, it's in blatant violation at this point. I've been told numerous times that I would have discovery, and I don't have discovery. I will also note for the record that it's my understanding Ms. Calipu has filed an appearance in this matter as a second chair or co-counsel with Ms. Curie. So again, I do not understand why the Attorney General's office is not currently here to explain why we do not have the discovery if it is the Attorney General's office that is handling the discovery in this matter.
And it's my understanding that they want to release what they have so far under a protective order that your parties haven't come to terms with yet.
To discuss the protective order in their email, which I have, and I will admit it as an exhibit.
I would actually ask that that be marked as an exhibit in both
So
files.
it's exhibit. She indicates that they are using a template from a child endangerment and human trafficking unit. Your Honor, this is a murder. And the template, and I referred to this briefly in my opening statement, the template dives into requiring us to reveal our defense, who we're going to use that might see the discovery. That is unheard of in a murder case. We have offered to negotiate. We have said that when it comes to medical records and any reference to any children, we will agree to a protection order, not a problem. But when it comes to the information regarding the murder, police reports, case law is very clear. We are entitled to it now. And so when we get a flippant response saying, I don't know if I have 100 pages or 100 files, 100 reports, you do know. The AG's office took this case on, became a part of it, has gone public, said we're in. They are assigned to our knowledge to deal with discovery. Wexford County is not. They have an entire unit that deals with discovery. They certainly have the resources, and to not have a piece of paper divulged and to come at us sarcastically when we're trying to get something done and our clients are being held in jail with no bond. Unacceptable. Absolutely unacceptable.
Your Honor, I will also note that as part of that protective order, when the defense indicated, as the email references, that we weren't going to sign that protective order, we were told, fine, then we will slow roll the discovery in a redacted format, which that does not comport with the law. The defense is not entitled to redacted discovery. And in light of the fact that the probable cause affidavit was released unredacted to the public, that's an even bigger problem.
One last note, Your Honor, and my partner reminded me. Materials are already ready from the state police and Wexford County through FOIA. We have been quoted a price on social media. Social media activists have been quoted a price for FOIA release of the documents we're seeking here.
And that's FOIA request to the county and the state?
Yes.
State police.
That is our understanding.
And so if it's ready for FOIA, stop playing games. Please stop playing games with our clients' lives.
Thank you. Mr. Carnes, anything in response?
Thank you. Just to clarify, on Friday, January 9th, AG Calipu sent the email, okay, no problem. We will redact the police reports and get them to you. I will let you know anything that wasn't provided and why. We will let you know when the discovery becomes available. I think the discovery will be available soon. Again, this was sent on Friday. It's now Tuesday. It was a weekend. I think there are issues to be ironed out as far as the protective order. That's something I think we can all work on, but to assume that the AG's office has essentially dug in their heels based on one email response, I think is not appropriate. So I'll leave it to the court's discretion as to whether to set a show cause regarding discovery. I would ask for the defendants to remain held without bond. very serious case, very serious allegations, and we will be working to get discovery released as soon as possible.
Do you know when your office started receiving discovery
I think it was
or discoverable
Thursday or
material?
Friday of last week.
That's when you started receiving it?
I believe so.
And are you receiving it simultaneously with the AG's office?
I think the AG's office is actually receiving it through us.
So you're receiving it and then sending it to the AG's?
Digitizing it, getting it to them is my best bet, but I would need our discovery clerk up here to know for certain how that's working.
Your Honor, may I approach? I want to enter this as an exhibit.
Yes.
Again, for the record, Your Honor, I would ask that this exhibit be marked as a joint exhibit between the two files, please.
Yes.
No objection by the people.
Your Honor, the one thing I would know that my colleague is that we're entitled to unredacted. There is no need to slow roll this through a process of redaction when the case law is very clear. In this case, we should get unredacted, and we're more than willing to agree to protective orders when it comes to medical records, HIPAA, and any kind of child interviews, child picture, things like that.
Assuming they exist.
Correct. Mr. Carnes, I know you're not necessarily assigned to this case, but do you know, are there still pieces of discovery that, or reports, things like that, that you haven't received yet?
I would say it is likely that that is the case, but I don't know for sure. I would also say that's pretty normal that we would have enough probable cause to hold people while the facets of the investigation are still ongoing. And I don't think anyone has used the word slow roll in discovery. I think all parties are working to get discovery released.
I'll state for the record, defendants A is received without objection. Give me a moment to look at that real quick. Anything else from anybody? All right. What the court is going to do is I'm going to set this matter for a show cause with both the Wexford County Prosecutor's Office and the Attorney General's Office to see why discovery has not been complied with pursuant to the 21 days provided by court rule. I do understand the argument that defense is making regarding bond. I also understand the complexities of this case. However, it has been going on for a month, and it sounds like there is information out there that the defense certainly is entitled to. I will make a determination regarding what we're going to do with the case with bond after we have the show cause regarding discovery. Is it possible to set a date for that now?
Can we just, it'd be easier to work calendars?
I'm sorry.
Setting the
date.
Yes.
Yeah, probably that would work better.
We could do the 30th.
What time? Anytime.
We could do morning.
Will the morning of the 30th work for everybody?
That would work for me. Huh? We'll make
I'll make it work, Your Honor.
All right,
What time?
let's do 10 o'clock. Anything else for the record, counsel?
nothing, Your Honor. Thank you.
All right, thank you.
Thank you. Your Honor.
Thank you.
Thank you, Your Honor.
This is case number 252875FY, appearances counsel.
Nick Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Rankin. He's joined me at the table.
And we are set for a probable cause conference. Is there any resolution in this matter?
There is not.
Looks like we are then moving forward to preliminary examination next week. Is there any discovery issues or any witness issues we need to be concerned with?
There is an outstanding same report that the prosecution has assured me is forthcoming, so I don't anticipate there being any issue.
Mr. Carnes, are you aware of anything else?
No, I'll just say it looks like that requires a protective order. I don't see one in the file. We'll draft that today and should be able to.
Do you have the same report?
I do have the same report. I don't see the protective order. I'll talk to our staff and get that done.
All right, we will keep this set for preliminary examination next week. Is there anything else we need to address?
Nothing.
No, Your Honor.
All right, thank you. Our next call is people of the state of Michigan versus Todd Allen Burns. This is case number 25-3733FT, appearances counsel.
Nick Carnes on behalf of the people.
I'm Jeff Harrison. I represent Todd Burns.
Mr. Burns, I'm sorry, Mr. Harrison, why is your client still in custody?
Why is he still-
Oh, Roscommon?
Yeah.
All right.
Yeah, I'm sorry, Your Honor, I didn't hear your question.
All right. We are here for a probable cause conference. Is there any resolution in this matter?
Not at this time. Your
There
Honor.
is none.
All right, so we are set for a preliminary examination for next week. Is there any discovery issues or witness issues we need to address?
I don't believe so, Your Honor. I've been provided with the police report. I don't think there's any other outstanding supplement or anything that would be out there. I think the investigation is complete.
All right, Mr. Carnes, are you aware of anything?
No, Your Honor.
All right, so we will keep this set for a preliminary examination for next week. Anything else for the record?
Nothing.
No, Your Honor. Thank you.
Thank you.
Is your client under sentence in Roscommon or what's going on there, Mr. Harrison?
I can answer it. They had a hold when, after I got my bond here, they had a hold from something previous. So I reported there too.
Okay, is that a new case?
No,
Is it a probation or,
no. It was a month before this one. Same person.
okay, but have you been arraigned? You've not been arraigned on it?
No, I have a bond.
You do have a bond?
And I have court there the 21st and here the 20th,
What is your bond?
7,500.
Okay. Well, the court is going to sua sponte bring a bond motion because he's currently a personal recognizance bond. So I will set a $100 cash surety bond so that he does accrue jail credit while he's incarcerated.
Appreciate that, Your Honor.
I had 200 in my account here too. Going to housing now. I didn't get a check before I left.
Court next calls the case of people of the state of Michigan versus Stephanie Ferrante. This is case number 2631FY, appearances counsel.
Nick Carnes on behalf of the people.
Robert Hertel for Ms. Ferrante, who joins me at the table.
All right. We are here for a probable cause conference. It does not look like there's a resolution. Is that correct?
Correct, Your Honor. But there is a waiver of the 14-day rule. The people would ask for an adjournment in this to give more time to exchange discovery and hopefully come together at a resolution.
How is discovery coming together in this case? You still have you received anything yet?
There are drafts that I reviewed, but MSP needs to review those before I can hand them out. So I would say it could be a week before we're final.
So with the waiver of the 21 days, that puts us at the 27th. Do you think that's sufficient time?
The 27th
January.
January, I would ask that.
Would oppose that, but if you could address bond going forward, I would appreciate it.
Mr. Hartel, any objection to addressing that? I'm sorry, Mr. Carnes.
No objection to defense raising the issue, Your Honor.
All right, so we will move this then to the 3rd of February. Mr. Hartel.
Yes, thank you, Your Honor. I did regroup with my client before coming in today. She does want me to address the bond situation. If the court was willing to consider lowering it, preferably to a personal recognizance. We do realize this is a serious case, serious allegations, but she's advised me that she does have family who is willing to put her up in a hotel room and pay for that, or an apartment maybe.
Yeah.
And that way she would have a firm residence. So if the court did still want to GPS tether her, she could do that. I just would hate to see her waiting in jail while this is continuing. And she does want to get all the discovery as well. For all we know, it might have exonerating stuff and it won't know until we see it. But at the same time, I would hate to see my client lodged pending that. Our office social worker, the public defender's office, Mr. Brian Henniger, will gladly help her. Well, he can't in all the ways that he can, but her, I believe mother, was it?
Yeah.
All right. Her mother is more than willing to help her initially get that. And if it is a GPS tether to an address, then obviously that would overcome some of the court's public safety concerns, hopefully. Thank you.
Mr. Carnes.
Thank you, Your Honor. I think bond is appropriate where it's currently set. These are serious allegations lying during a home invasion murder investigation. And the defendant has extensive criminal history from Kentucky and appears to have resided in Kentucky. So I think the seriousness of the offense and the defendant's lack of ties to this community are both concerning. I would ask court to keep bond where it's currently set. Thank you.
All right, when looking at the bond factors in 6.106, the court has considered the prior criminal record, so let's run through that. In 06, there was a robbery second, possession of forged instrument, theft, receipt of a stolen credit card or debit card, possession of burglary tools, theft, a receipt of a stolen credit or debit card. Then in another case, there was another robbery second, possession of cocaine, possession of burglar tools, theft, or receipt of a stolen credit or debit card, possession of a forged instrument second. In 6, there was a theft by unlawful taking, and in 17, a shoplifting under 500. Record of appearance or failed to appear. The praxis does not indicate that she has any failed to appears. A flight to avoid prosecution, there's nothing regarding that. History of substance abuse or addiction. The only thing the court has in that regard is back in 06, 20 years ago, possession of cocaine. Mental condition, character, reputation for dangerousness. The court has nothing regarding that other than the criminal history and the robbery second that goes along with that. The seriousness of the offense. She is charged as a habitual fourth offender, which makes it the 4-year felony up to a 15-year felony. Probability of conviction and likely sentence isn't going to be scored to her yet.
No, Your Honor, I have not.
No.
Employment, financial status, and history. I have not heard anything regarding that. Responsible members of the community who would vouch or monitor for her. Ties to the community, relationships, length of residence, and any other factors regarding risk, appearance, and danger to the public. I'll admit what the court knows on this case is limited exclusively to the affidavit of probable cause, which indicates that she was with somebody who is believed to have murdered somebody and then lied during the investigation. I also note, as Mr. Carnes did, that her criminal history is out of Kentucky. I don't know for certain what her ties to the community are. I do know at one point she was living in the homeless shelter, and then at another point had spent a couple days in a motel room. And then it does sound if she were to bond out, that she would then be placed in another hotel room possibly, which makes her very transient in nature, which does indicate that she is a potential flight risk. I also, based on what I know in the probable cause affidavit, or have read in the probable cause affidavit, I believe that she is also a threat to the community. Bond was set on this case back on January 5th with a $250,000 cash surety. I believe the bond is appropriately set, and I'm denying the request. Anything else for the record?
There you are. Thank you.
No, thank you.
I will say this, however, with discovery having not been provided yet, I realize we're not within the 21 days, but that would not stop me from reconsidering another motion in the future, pending what happens with discovery. Court next calls the people of the state of Michigan versus Jeremy Joe Powell. Can we, yeah, I'm not gonna have, I didn't realize it was a plea to a felony. We're not gonna have time to do it. Oh, and it's a Killebrew 7411. So is that correct?
It is.
Yeah, so I'm not gonna take a sentence agreement plea.
Oh, so we just want to.
You would just waive and bind over to the circuit court.
That should be fine.
Okay.
Fine.
I have to- okay.
Are you okay if I go on after arraignments then and cannot be brought?
Yes.
Okay. Mr. Kurtz.
So more time to.
Then we're done.
This way I would have. Oh, you were saying. Sometimes we can't.
Amy, we're gonna put Bowler on after arraignments just to read his
Okay.
amendment and then sign his waiver.
Yep, I got that. Okay. I have to do something with tech support on my end, so it might be Mr. Harrison, but if it's just for an arraignment, that should be fine.
Yes.
You need to handle bullets or.
You may. Before I sign this, is there anything else we need to address on the record?
No, you're on.
No, you're on. I didn't realize you're still there, Jeff, sorry.
All right, I have signed the person at the jail. Please state your name for the record.
Douglas Messiah Finney.
All right, this is case number 26130FY, the people of the state of Michigan versus Douglas Messiah Finney. We're here for an arraignment. Sir, did you have the opportunity to meet with somebody from the public defender's office today?
Yes.
I have a complaint that alleges that on or about January 12th, 2026, in Wexford Township of Wexford County, it is alleged in count number 1 that you committed the offense of harboring a felon. That is a felony punishable by up to 4 years in prison and or a fine of $5,000. The prosecution is elected to charge you as a habitual 4th offender, which means that you have at least 3 prior either attempted or completed felonies in your past. That makes that 4-year felony a 15-year felony. Do you understand those charges and the potential penalties?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you cannot afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I have an appointed attorney.
Well, you don't have one yet. You may have met with one this morning, but he hasn't been appointed yet. So are you requesting that the court appoint an attorney?
Yes.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea in this case. We'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. And at that hearing, the prosecution will be required to prove 2 things. 1, probable cause that this crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecutor is not able to do that, the case would be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Mr. Finney, you met with somebody from Community Corrections this morning and gave them some contact information. Is that information accurate?
Yes.
Right. Historically, counsel, I show in 13 a minor with any BAC as a second. There were 2 joyrides in 15, an attempt to resist and obstruct in 16, a B&E without intent and home invasion 3rd in 17. In 20, there was prisoner possession of contraband, 21, 2 CSC 4s, in 23, a CSC 4. In 10, there was a HIDA case, B&E, a vehicle, steal less than $200. He's had an MIP and 2 disorderly drunks automatically set aside. And then on the local record, but not a CCH, there appears an intox from 13. Praxis scores him at a risk level 2, but indicates there were no prior violent offenses. My reading of the rules for the praxis is that the CSC would count as a violent offense, so I believe that's improperly scored, and he should actually be 3 instead of 2. Any comment regarding bond, Mr. Harrison?
As I understand it, Mr. Finney's involvement in the current matter is somewhat an open question. He's a local resident. You know, he's been around all of his life in the Cadillac area. He has substantial ties to the community. There's no reason to assume he would not report back to court. I don't see anything in his past that is of a concern in that regard either. Thank you. Good candidate for PR.
Thank you, Ms. Lawrence.
Your Honor, I will admit that eventually after some time he was honest with officers and cooperative. That being said, the half-board does make this a relatively serious felony. For whatever that's worth, I will leave bond up to the discretion of the court. At this time, I would just ask for a no contact order with the co-defendant.
Sir, if I were to release you, is there anything that's going to stop you from coming back to court?
No.
Do you have any fail to appears in your past?
No.
All right, as a condition of your bond, I'm going to order that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes.
I believe that he and Mr. Bartachowski reside in the same residence, which would be his co-defendant.
All right. I'm also going to order, I'm not going to order the no contact at this time. I do not find the defendant, based on these charges, as a threat, nor do I find him as a flight risk. So I will release the defendant PR. He is to enroll in community corrections services, though. So, Mr. Finney, at some point, you're going to be released from the jail today. You'll need to come over here to the courthouse, which is about 5 blocks from where you're at, and get signed up for community corrections services. All right?
All right.
Next arraignment, person at the jail, please state your name for the record.
Kevin Bartachowski.
This is case number 26-129FY, the people of the state of Michigan versus Kevin Michael Bartachowski. We're here for an arraignment. Sir, did you have the opportunity to meet with somebody from the public defender's office?
Yes, Your Honor.
You also, looks like, met with somebody from community corrections and gave them some contact information. Is that information accurate?
Yes, sir. Yes, Your Honor. Excuse me.
I have a complaint that alleges that on or about January 12th, 2026 in Wexford Township of Wexford County, it is alleged in count number 1 that you committed the offense of harboring a felon. That is a felony punishable by up to 4 years in prison. and or a fine of $5,000. Additionally, the prosecutor has elected to charge you as a habitual fourth offender. That means that you have at least 3 either excuse me, completed or attempted felonies in your past. That makes that 4-year offense a 15-year offense. Do you understand those charges and potential penalties?
Yes, Your Honor.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to stop answering questions that you consented to, and the right, I'm sorry, the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you cannot afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I'd like to be released so I can represent an attorney, Your Honor.
I'm sorry, I didn't hear you.
I'd like to be released so I can afford to represent an attorney, Your Honor.
So your intent is to hire an attorney?
Yeah, I'd like to, because I don't even know this person that they're talking about, and I'm not from the state, Your Honor.
Do you have the financial means to hire an attorney?
I run my own business, and right now I'm receiving a check after I finish this job that I'll be able to afford an attorney.
All right.
Right now, I financially don't have nothing. I'm just making it by means.
All right. So I'm going to mark that you're going to hire an attorney. If something happens that you can't hire one and you still want an attorney, you can always request a public defender. Do you understand that? You'll just need to let the court know.
That's Your Honor.
All right, so the court will enter a not guilty plea on your behalf. We'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor is required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecutor is not able to do that, the case would be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show all out-of-state convictions. In 03, there was some sort of possession of liquor. In 04, a robbery. In 05, assault, which was a felony 3 out of Illinois. In 13, resist a police officer. In 16, assault felony 2. In 21, a damage to property. In 23, a burglary. In 23, a resist an officer. Those are all out of Illinois. The praxis scores him at a risk level 3. However, it does not score any points for history of violent offenses. I believe the felonious assaults would fall into that category. So I believe that he should receive 1 point for that, which would increase his risk level from a 3 to a 4. Mr. Hartel, I know there's an indication that he's going to hire an attorney, but do you have any comment regarding bond?
I do, Your Honor, and even though he's a 4, that's still in the released category as far as press. The main concern that I anticipated for the court was his statement that he's from the city of Chicago, and he certainly is, but he has moved here and is residing in the same residence as Mr. Finney locally here in town. There's no reason why he would deviate from that during the pendency of this matter. Again, despite the fact that he does have some degree of criminal history from Illinois, looks like most of that was a significant time ago, and that has nothing to do with the allegations in this matter. It's a similar situation to the other gentleman we just discussed. I believe him to be a good candidate for PR as well.
Thank you, Ms. Lawrence.
Thank you, Your Honor. I do not think this defendant is a good candidate for PR. He was extremely uncooperative with troopers. Even after he was placed under arrest, the report states he was belligerent with jail staff and troopers. demanded to be transported to the hospital, in which he was extremely belligerent with hospital staff as well. Given his criminal history, people do have some concerns here. Additionally, all of his criminal history being out of state, I think there is a flight risk here. The defendant just said himself he is not from here. So I have some serious doubts as to him staying here, and as well as his community ties within our community. So I would ask for a $10,000 cash surety bond. I would also request a no contact order with the co-defendant.
Mr. Bartoszewski, I know the praxis says that you've lived in this residence for 4 months. How long have you been a resident of Michigan?
I came down here like in the end of July, Your Honor. But the reason why I had arguments with the staff is because they hit me with a barrel of a gun in my chest, and I have atrial fibrillation. I just had a stent put in my heart. I was in atrial fibrillation. I was having heart problems, and I previously had a stroke, and I had problems with my heart. That's why I had a problem with staff, because I had problems with my heart. I have atrial fibrillation. And they were not giving me, release me to go get medical attention. I had to wait 2 hours to get medical attention. That's why I was aggravated and stressed out, because atrial fibrillation is when you go into having a minor heart attack and having close to having a stroke. That's why I had problems. I was trying to get medical attention for my heart.
Eventually, were you taken to the hospital?
2 hours later.
Okay, and were you cleared? Did you receive medical clearance to go back to the jail?
After everything was all calmed down, after 2 hours, yeah. When I was in the time when I was in atrial fibrillation, yes,
Right.
I was in atrial fibrillation, but when the time I went to the hospital, I was not. So they refused me medical attention.
And so
when
I
was in
just want to make sure I want to make sure I heard you correctly. You said you arrived in Michigan about the end of July, roughly?
something July or something like that, or August or something like that, yeah.
All right. All right, sir, as a condition of your bond, I'm going to order that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also ordering that you not act in any threatening, intimidating, and harassing behavior. You must enroll in services with community corrections.
So I'll be released today.
Well, we're not to that point yet. Bear with me. How long ago was it that you were released from prison for your resistant officer?
That was a long time ago. That was a long time ago, Your Honor. That was a long time ago. I've been going good. Man, my last charge, Your Honor, to be honest with you, my last charge of robbery, I didn't even commit that crime. I got charged with that crime and I pled guilty because of my background and shit like that, but I didn't commit that crime. That's the first case I was actually innocent on, and I had to do time on some time I didn't do it. All the other ones I've been completely guilty of. But all the other ones, but that last one I did not do, and I got charged with it. I had to do time.
Were you on any type of supervision after you were released from prison?
I don't know as far as what you mean, but yeah, yes, sir.
Okay, and when were you released from parole?
August. Oh, I got off early. I believe it was before August or something like that. My parole officer got me off before because I was good. I had all clean drops. I don't do no drugs. I passed I took my classes and everything. I got off early.
Okay, so you're talking pretty fast, so I want to make sure I understand you. Hold on. All right. Did you say you were released early from parole?
I believe I was because I completed all my classes. And I passed all my drug tests. I don't do no drugs. And I'm sorry, Your Honor, I got ADHD, so I speak a little fast because I have my ADHD. And plus, I'm mixed with my accent.
And when you were released from parole, is that when you came to Michigan?
Yes, Your Honor.
All right. Okay. All right. All right. I am going to release the defendant on your own personal recognizance, which is your promise to come back to court. Along with those other conditions. So what you're going to need to do is at some point you're going to be released from jail today. You'll need to come over to the courthouse, which is about 5 blocks from where you're at, and get signed up for community corrections. All right.
Okay, Your Honor. Thank you.
All right. Next arraignment. Person at the jail, please state your name for the record.
John William Huntley.
This is case number 25-4334 SM, the people of the state of Michigan versus John William Huntley. Sir, you met with somebody from Community Corrections today and gave them some contact information. Is that information accurate?
Yes, it is, sir.
Did you have the opportunity to meet with somebody from the defender's office today?
I did.
I have a complaint that alleges that on or about August 10th, 2025, in the village of Niesick of Wexford County, it is alleged in count number 1 that you committed the offense of aggravated assault. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000, and consecutive sentencing may be imposed if it happened in a place of confinement. Do you understand those charges and the potential penalties?
I do, I don't know the person in general that I apparently committed them on, but that's a later date, but yeah, I know.
Do you know who the charge alleges that you were allegedly assaulted?
I've heard the person's name, I don't know the person, so I think they got me, so.
Okay, did you read and sign an advice of rights form there at the jail, talked about your
Yes.
rights to an attorney and your rights to a trial?
I did, sir.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request an appointment of attorney.
All right, court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf, and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, historically, I show in 06, driving the license suspended, in 10, a driving the license suspended, another one in 10. In 19, there was a use of methamphetamine. In 20, an attempt to resist and obstruct. In 23, a driving the license suspended. In 11, there was a 4A case. In 09, there is an operating without a license or failed to display a license. The defendant currently has a warrant for probation violations for a controlled substance case, and has, by my count, 4 failed to appears in his past. The praxis scores him at a risk level 5. Comment regarding bond, Mr. Harris.
Indeed, it's our understanding that Grand Traverse County has a hold on him. So due to this warrant that they have for a probation violation, so it's somewhat academic. I would have you set a bond, a nominal cash bond. So once that matter is resolved and the hold is lifted, he could apply it and be released pre-trial in this case.
Thank you, Ms. Lawrence.
Thank you, Your Honor. And it's my understanding the defendant does in fact know the victim, at least based off the report. The victim was the defendant's girlfriend's ex-boyfriend. And he essentially attacked him completely unprovoked. The victim did have pretty serious injuries, bruising to his face, a nosebleed, possible broken jaw. He was at a later point evaluated by EMS. I would ask for no contact with the victim. While I understand this case is a little bit older, our office has not had contact with the victim at this point in time, so I would still ask for that. I would ask for a higher monetary bond. I think his outstanding warrant, as well as his several failure to appears, clearly show that he is a flight risk. And I have serious concerns that if given the PR bond, despite the hold he currently has, we likely would not see him back here. So I would ask for a higher monetary bond in this case. Thank you.
All right, thank you. According to Lean, it looks as if he has been missing from Grand Traverse probation since July 8th. That looks like that was the first fail to appear. Defendant was also on bond at the time that this event happened, and as I said, it looks like he's got 4 prior fail to appear, so I do find him as a flight risk. Accordingly, I believe a monetary bond is appropriate. Court will set the bond at $10,000 cash surety. Defendant is to appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. I'm also going to order that you not have any contact with Justin Greenwood. No contact means no contact of any kind, phone, text, email, social media, or anybody acting on your behalf. If you are found to be in violation of your bond, you could be arrested without a warrant, brought back to jail, and have your bond revoked. I'm also going to order that you not purchase or possess any firearms or weapons. You not act in any threatening, intimidating, or harassing behavior. Next arraignment. Sir, could you please state your name for the record?
Blaine Morgan Merritt.
All right, this is case number 19-3548FY. The people of the state of Michigan versus Blaine Morgan Merritt. Mr. Merritt, you met with somebody from Community Corrections today and didn't give them any contact information. Do you not have a phone number or mailing address?
Nope.
Did you have the opportunity to meet with somebody from the defender's office today?
Yep.
Is that a yes?
Yeah.
Sir, I need either a yes or a no, please.
Yes.
I have a complaint that alleges that between the dates of August 1st, 2015 and December 31st of 2016, it's alleged that you failed to pay child support based on a order from the Wexford County Circuit Court. As of the filing of the warrant, which was back, or the filing of the complaint, which was back on July 15th of 19, the amount outstanding was $20,032.13. Do you understand those charges and the potential penalties? I'm sorry, that's a 4-year felony. That means you could be sentenced to up to 4 years in prison and or a fine of $20,000. Do you understand that? 2,000, I'm sorry. Do you understand that?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. If you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
He's attorney sitting right there. I already talked to him.
Well, he hasn't been appointed yet. So, and even if we do make a referral for an appointment, there's no guarantee it would be Mr. Harrison. But are you asking for the appointment of an attorney?
Yeah.
All right, the court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor will be required to prove two things. One, probable cause that the crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecutor is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 12 and operating without security, in 15 have failed to pay child support, in 12 operate without an endorsement, and in 95 there was a trespass charge from out of state. The praxis scores at a level 6. Any comment regarding bond, Mr. Harrison?
Well, I remain a bit confused with regard to the status with the court. I realize that you present something of the memo presenting no fixed abode and or contact information. That point seems obvious to me that this is an extremely old case. The warrant that I was provided was signed by Judge Bill Fagerman in 2016.
Yeah.
So obviously he hasn't had substantial contact with police or courts or anything in the interim. And I don't see any reason other than the obvious ones why retaining him now makes any sense. We could find him a place to go and a contact to have, we might be able to obtain his pretrial release in terms that would be acceptable to the court. At this juncture, given the situation with the case upstairs, which we'll be addressing at 3:30, I would have the court set a bond so credit is properly allotted.
Thank you. And we'd heard from the Attorney General's office that they did not plan to appear today for this arraignment. Given that the defendant, so it appears, based on lien, that he was put in absconder status from probation back on November 21st of 2016. So he has been an absconder from court supervision for some 9 years. He does not have a mailing address, contact information, so I do find him a flight risk. The statute does require that bond be set at least 25% of the amount owing, which at least back in 19 comes to $5,008 and some change. However, given that he has been absconding in another case, a bond will be set at $10,000 cash. If he is able to post bond, he is to appear as ordered, keep contact information current, not leave the state without permission, and to commit no new crimes, and must enroll in community corrections services. Corrections, can we have Mr. Bowler, please?
Yes, sir.
Thank you. Sir, can you please state your name for the record?
Christopher Lee Bowler.
All right, this is case number 25-5160 FY, People of the State of Michigan versus Christopher Lee Bowler. Appearances, counsel?
And Carnes on behalf of the people.
Heard itself, Mr. Bowler, joint specimen from the Wexford County Jail.
All right. And we were originally scheduled for a preliminary examination. However, I see that there's a waiver attached to the file for me to sign. But there's also been a third amended complaint filed in this case. And so before I sign the bind over, we need to arraign Mr. Bowler on the amended complaint. Mr. Hartel, were you aware of that?
Yes, Your Honor, and I have discussed those changes and why they're being changed with my client.
All right. So, Mr. Bowler, the new complaint alleges that on or about December 23rd, 2025, in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of police officer assault, resist, or obstruct. That is a 2-year felony and or a fine of $2,000. And consecutive sentencing may be imposed if it happened in a place of confinement or for another violation arising out of the same occurrence. In count number 2, it's alleged you committed the offense of malicious destruction of a building, $200 or more, but less than $1,000. Is there PC on that?
Which one?
Count 2?
Yes, yep, there is a new PC that came through.
That is a misdemeanor punishable by up to 1 year in jail and or a fine of $2,000 or 3 times the amount of the destruction, whichever is greater. In count number 3, it's alleged that you committed the offense of public officer assaulting or obstructing. That is a felony punishable by up to 2 years in prison and or a fine of $2,000. And again, consecutive sentencing may be imposed. In count number 4, it's alleged you committed the offense of public officer assaulting or obstructing. That again is a 2-year felony and or a fine of $2,000 with the potential for consecutive sentencing. In count number 5, which is the new count, it's alleged you committed the offense of malicious destruction of personal property, $200 or more, but less than $1,000. That in of itself is a 1-year misdemeanor and or a fine of $2,000 or 3 times the value of the property destroyed or injured. However, they are charging you as a second or subsequent offender because you had a prior either completed, well, it looks like it was an attempted malicious destruction of property, $200 or more, but less than 1,000 from back in 2020. That makes that 1-year misdemeanor a 5-year felony and or a fine of $10,000 or 3 times the value of the property taken. I'm sorry, destroyed. They've also elected to charge you as a habitual offender 4th offense, meaning you have at least 3 prior either attempted or completed felonies in your past. That makes each of those 2-year felonies a 15-year felony and the 5-year felony up to a life offense. Do you understand those charges and the potential penalties?
Yes.
All right, you do have the same rights that you had during your other arraignment, so we will go ahead and continue the appointment of an attorney and enter a not guilty plea in this case and continue the bond as previously set. Counsel, before I sign the bind over, is there anything else we need to address for the record?
There you are. No, thank you.
All right, then I will go ahead and sign that, which I have done. So thank you, Mr. Bowler. Thank you, Jail.
Thank you, Your Honor.